These are common arguments or defenses that either do or do not work for speeding. Let's go. First of all, I'll start out by saying that there is absolutely no legal valid excuse for speeding whatsoever. The only thing that might work if you were actually guilty of speeding is mitigation, but I will cover that in more detail in another video. So now down to the arguments that might actually work as defenses if you are charged with speeding. And almost all of these are technical reasons. One of them might be incorrect, obscure, or even potentially unfair speed signage. In previous cases, courts have decided that drivers should be given proper guidance on the speed limits and enough time to be able to safely decrease their speed. That's why in some areas you will see the 3-2-1 markers before the speed limit changes down to 30, perhaps from a national speed limit. This is very often the case going down country lanes when you're approaching a small village, where the speed limit is quite rightly set at 30. If you can show that these signs were either incorrect, obscured, either obscured by trees or by snow, or in some rare cases when you can show that they were unfair, inadequate, or in some sense just plain wrong, you might be able to challenge a speeding ticket on this technical basis alone. Many people talk about the accuracy of speed cameras and are quite right to say that they are not 100% reliable. That's why the cameras have to be tested and calibrated regularly, and although malfunctions and inaccurate readings are in fact rare, if they have been improperly calibrated, this might be a technical reason that the camera has triggered at a lower speed than perhaps it should have, and again this might be a technical reason you could challenge a speeding ticket. Other grounds might revolve around the ticket itself. You see, you will receive notice of an intended prosecution, whether that is verbally from the police officer or sent to you through the post, which should be within 14 days. Either way, you should check all of the details of this very carefully, because the time, the location, and the vehicle in question have to be accurate, because if anything is missing or incorrect, you might have a case to defend it. For example, if the police say that it was a BMW when in fact it was a Mercedes, you might have an argument that the police officer was in a rush to get this ticket done, and therefore the police officer wasn't carrying out their duty with proper skill and care, and thus how can they be certain that you were in fact speeding? But just to clear up a bit of confusion, minor spelling mistakes, typographical errors, or even writing your name in capitals, all of these kind of things are not going to help you in this kind of a technicality. So don't even waste time and the risk of receiving a more severe penalty by going to court just because of a typo. Another ground, which in one sense is technical but is also factual, is if you were not the person driving and you can prove it. If you have hard evidence that you were in fact somewhere else, an alibi if you like, then you can show that you were not the person driving the car. Because when you receive a notice of intended prosecution, you also receive what's known as a Section 172 notice. This is a notice to identify the driver and puts you under a positive obligation to provide details as to who the driver was, and if it wasn't you, to carry out reasonable diligence and to show that you've carried out reasonable diligence, to show that you've tried to find out who was driving, and either you could or you could not find out who was driving. It simply won't be good enough just to tell the court that you've tried and you don't know who was driving or you don't remember who was driving. You will have to show and demonstrate that you have carried out reasonable diligence to try to find out. And as another side caveat to this, don't under any circumstances either take points yourself if you know someone else was driving, or vice versa, say someone else was driving if in fact it was you. This would be a far more serious offence than the speeding itself. Now we come to timing and time delays. There are two separate time periods that you should be aware of. The first is 14 days. You must be given notice that you're going to be prosecuted with this offence. Now don't confuse being stopped by the police and then not receiving one through the post, because if the police officer tells you in person that you are going to be prosecuted and offers you the notice, even if you refuse that notice, you've still been given notice that they intend to prosecute you. But if it's an automated or fixed camera, then yes, you should receive this through the post within 14 days. But it's only the first issuing of the notice of intended prosecution that requires to be sent within 14 days, and this is sent to the registered keeper of the vehicle. If subsequently it is passed on to somebody else, another driver is nominated as the person driving, it will still be taken that the police have complied with their requirements for the 14 days by sending it out to the registered keeper of the vehicle. If you or the registered keeper of the vehicle, to be clear, hasn't received this notice within the first 14 days, then you have reasonably good ground to contest the speeding ticket. But just to be clear, there is no guarantee that you're going to win any appeal, and certainly no guarantee that you're going to get a not guilty verdict if the court disagrees and believes that you were guilty of the offence. In which case, again, the penalties are likely to be more severe in court. Now for a few things that people think that will work as a defence, but in fact they won't. Simply saying that you didn't notice the speed limits changed is not going to get you out of a ticket. In fact, quite worse, it's more likely to show that you were not driving with due care and attention. In other words, paying attention to the speed limit changes. Next, some people say that they are driving in an emergency situation and this was why that they are speeding. Now, whilst it is possible that an emergency caused you to speed, this isn't going to be an excuse if you go to court and try to challenge it on those grounds. Although it's something that will be considered, you'll still most likely be found guilty, but you could perhaps use it in mitigation. What's more likely is the court is going to suggest two things. Firstly, that you should have contacted the emergency services because that's what they're there for. And secondly, if you were in an emergency state, you were not in a fit state to drive and shouldn't have been driving at all, let alone at speed. Another excuse people come up with is the 10% plus 2 rule. Some people think this is built into legislation and it is a hard and fast rule that you can drive 10% plus 2 miles an hour above the speed limit, but this is just not true. It is not built into legislation, it isn't law, it is merely guidance from the national police chiefs that they only prosecute if someone is exceeding those tolerances, but that's all they are, is a tolerance. And finally, some people try to argue that the roads were empty and therefore it should be safe, even though they were speeding. But again, this is not an excuse that the court is going to accept. It's not an excuse that the police are going to accept. And again, the court is likely to take another view where you are tempted to break the rules because of an empty road, and thus making you a danger to yourself and to other people. So again, this excuse is not going to work. And finally, as with everything in my videos, none of this can be taken as legal advice because it would not pertain to your particular circumstances, so you must seek formal legal advice if you were to use or think about any of these defenses for yourself. In the meantime, please like the video, remember to subscribe, and thanks for watching.